Hello?
Hello, good afternoon. Could I speak to Mr. Hussain, please?
Yes, speaking.
Hello, Mr. Hussain. My name's Jake. I'm calling from the Legal Ombudsman.
Oh, hi, Jakes. How are you doing? Thanks for calling me back.
Not too bad, not too bad yourself.
Yes, I'm okay. I'm okay. It's a bit of an echo on the line. Have you got it on speaker?
I'm on my headset. I'm in an office room which is pretty empty in here. So
Oh, I see.
I wasn't able to get one of the key pods that we have, so I've just got an office room
Okay.
that's private for ourselves conversation.
Okay, not a problem. Not a problem.
Okay, so just before I go on, obviously we've gone through it a few times, so just to go through again, we'll just need to go through security with you. Can you just confirm your email address for me, please?
fatabegum@gmail.com.
Brilliant. And can you just confirm your postcode?
Bravo Delta 24 Romeo Tango.
Brilliant. And the service provider?
Burke Niazi Solicitors.
Thank you very much. Fantastic. So what we're here to discuss is obviously we've had the phone call with your service complaint to a stage one. The reason for the phone call is that we wanted to go over the other key points that were brought up in the resolution. Is there anything that you'd like me to go over before we go into that?
Yeah, I just wanted to know. I mean, obviously, can I just ask when was the last time you spoke?
Me and yourself?
Yep.
Verbally or by email?
Verbally.
Verbally. So we spoke. Last time we spoke. Let's have a look. We spoke on the 11th.
All right. So we spoke on the 11th of July.
Yep.
Yep. Okay. And obviously, in that conversation, we discussed only one of the points, which was the last point.
Yeah.
Namely, I think the university decided to end the case prematurely. And after the call, that resulted in me raising this as a complaint, a further complaint. Is it level 1 complaint?
Moving it to a stage one, yeah.
Yeah, stage 1 complaint. Yeah. So, just before we delve into the remaining points, I just wanted to ask that I've not really heard anything back, or I got any update regarding the stage 1 complaint.
Oh, right. Okay. So with the stage one complaint, there is a process that goes through with a stage one complaint. I have put their email address on there as well. Now it can take up for a stage one complaint. I think it can take up to 6 weeks for them because they've got to review the complaint and go through it to make contact with yourself. It's a service complaint team, so I have given their direct contact email address if you do wish to correspond with them between them picking up the complaint, the service complaint as well. But as I said, I will be adding more onto it after we spoke if there's any other areas that you want me to pick up with.
Yeah, okay, that's fine. I mean, like I said, you've made me aware that it takes up to 6 weeks, and I won't be contacting them because obviously you've escalated it. So me contacting them is not gonna precipitate a faster issue, is it? It's gonna take as long as it normally takes.
Yeah,
You see, so.
I mean, if for example, after our phone call today, there's any further things that you want to add, you can contact them directly from using that email address.
Okay, all right, and that's.
By post.
And that's stage 1 complaint, and that's covering your handling of the investigation, isn't it?
Stage 1 complaint is handling from the fact that we've not been able to come to a resolution. You haven't accepted my resolution.
Okay.
We get something to a stage 1 complaint, but with those areas, I can bring up obviously with the areas. What am I dealing with the case? It will be reasons why you're unhappy, which you've obviously advised.
So, the stage one complaint is that obviously they're not looking at the service provider, are they? Because that's obviously done by the investigator. The stage one complaint is going to be looking at the handling of the my issues with your associate Jeffrey, what's the name? Sean Jeffries. And then subsequently your attempts at a resolution which I'm not happy with, and so that's going to be reviewed. Okay, that makes it clear, and then that's going to take, like you said, up to 6 weeks before they get back to me. And after the call today, if there are any other issues, you can feed them back to that first stage one complaint just as addendums. Yeah, okay, I understand that. That's fine. Yes, I just wanted to get that clarity before we begin. So I would like to just have an opportunity to go through the other, because I think there was eight points something. 1, 2, 3, 4, 5, 6, 7, 8. Yeah, there were 8 different points that you had listed, and we had managed to go to the point number 8. So do you have those points in front of you?
Yes, I do. Yeah.
Okay, all right. Yeah. So the first, what's the first one?
The first one, time it took for the investigator to give you the team leader contact details.
Yeah, I mean, and you had concluded. Just remind me what you had concluded.
Yeah, so going over the telephone conversation which was made on the 11th of May between yourself and Sean Jeffries, it was then when you asked Sean Jeffries for team leader details, which he gave you over the phone, and also confirmed in the phone call that this can be emailed directly after the call.
Yes, I mean, if you had listened to the call, my complaint was not the fact that she'd not given me the contact details, because evidently she had given me the contact details. My complaint at the time was that she was being very evasive in not forthright and coming forward with those details. She was trying to say, she was not basically trying to give me the impression that there was nobody else involved. And I had to say, well, no, obviously you must have a manager and stuff, and I want the name of the manager. So it was the aspect of her giving me the team leader, like your name and details, was not forthcoming. It's not the case that she didn't give me the details. I obviously had to press upon her. It seemed that after she was like, you listened to the call. After I had to press her upon it, she had to then, obviously, she was left with no choice. And my complaint was that, she had attempted to fob me off initially. Would you not agree that was the case, that she had initially attempted to fob me off, stating that,
When I listened to the call, Mr. Hassan, I didn't find that because she was going through the processes, so I didn't feel from listening to the call and even how the conversation was going, when it was brought up with obviously taking, what's the next escalation from a complaint would you report to, I didn't see any resistance from Sean with giving those information.
Okay, all right. Well,
giving those information.
Okay, all right.
From the telephone conversation, I felt that the information that she gave you was on point from.
Okay.
That would have been that is also a step for a process. So for her to hold it up, which I didn't feel she did, all it would have done is would have impacted her in a negative way. So
yes,
her giving this information. Yeah.
I mean, if you remember in our call, and I said, like, it's only good customer service. Like, if I was not happy with her, it was upon her to say, look, Mr. Hussain, if you're not happy with anything I've done, for her to advise me, to say, like, oh, I think that's only good practice. No, you think it's like, if I was raising a complaint or I had issues with her, it would only be incumbent upon her to, make that information readily available to me. That's what I think what the gist of my complaint was. It was something that I had to press her upon, saying, look, I'm not happy with this. I'm not happy with the way that this has been handled. And what's your manager's name? And at that point, she said, oh, okay, I understand. We have a policy in here. Whenever a member of the public or the complainant is dissatisfied with us, I can then direct them to our complaints procedure. What I expected was, oh, look, this is the name of my manager. If you have any complaints, please contact him. Taking the proactive approach. However, in the call, it seems that when I was trying to raise a complaint, she was quite clueless on the subject, and I had to reiterate to her that no, obviously you don't work in isolation. You obviously are managed by somebody or supervised by somebody, and so therefore I would like the supervisor's name. And it's at that stage that being confronted with my refusal to accept the circumstances as she was presenting them, that she then conceded into providing me with your contact details. That's the only point that I was trying to say. Now, if you after having listened to the call, if you're still concurring with her that is it not clear that she did not take any proactive steps to, identify what the procedure was? She effectively was trying to, as I would say, trying to be evasive, and you have a different take on that.
I don't feel that she was trying to be evasive. I think from listening to the call and kind of like gathering from how the conversation went, I think from the time when obviously you mentioned dissatisfaction with her service, obviously from any investigator, it's upon themselves to see if they can resolve what the dissatisfaction is at first stand. And then as soon as it was mentioned regarding, have you got a team leader, manager's details, she didn't resist in giving those details and obviously went on to give the details.
Okay.
I think from what you mentioned about the clarity of where she could have maybe hesitated would have been just to make sure that she was clearing up the process. But from what I could hear from the phone call, I didn't feel there was any resistance from her giving these details.
Okay. And I think that's a key aspect here. It was not the fact that she. My complaint was that not that she didn't give me the contact details, because evidently she did. That's evidential. What my complaint was, as you can appreciate, that was not the case, because for you can say, well, we can evidence the fact that no, actually he did. She sent you an email. So what are you talking about? That was not my complaint. My complaint was that there was some resistance from her being evasive. Now, so that remains a point of difference between your interpretation after listening to the call and my interpretation, because obviously I felt resistance, I felt evasiveness, and therefore to a point where I've actually articulated that to yourself. So when it says here that when it says here that your what you've said, what you've investigated, I mean, I think that should have been quite clear that was, I did not ask you to investigate whether she gave me the contact details and for her to say, well, look, here you go, there's the contact details. Yeah, I did give it to him. That was not the that was not my complaint. My complaint was effectively that there was resistance, which you're stating that there was no resistance after listening to the call. And obviously this matter is now going to be looked into again by the stage one, who then can make hopefully another look at this, because obviously my main issue here is that when things had gone wrong, as you can appreciate, and as you now have fully accepted and agree with me, that when things have gone wrong, you can say, all right, look, we've got policy here, this is what the policy is, and I felt the fact that it was myself that had to overcome that resistance. But if you've looked into it and you're saying that there was no resistance, then obviously I disagree with that, and I would like somebody else to look into this.
Okay,
Yep. So that deals with the issue of Sean Jeffries' resistance or to provide me with the details and being evasive. What's the next one?
Next one, misleading information was given surrounding case decision comments and service complaint feedback.
Okay. Misleading information. What is a misleading information?
Misleading information was given surrounding case decision comments and service complaint feedback. So this is when you advised that basically she hadn't given you clarification as to what the next steps were from you giving comments on the case decision or the dismissal, and also giving you the correct processes to do a service complaint to myself. So from listening to this, I can kind of like say reviewing the evidence from the telephone conversation on the 11th of May between yourself and Sean. You have requested a timescale. You have requested a timescale of when an ombudsman decision would be given, and Sean had given you the correct information on the timescale, on a time frame. However, from my review, I can see that you were not giving clear instructions on what on a service complaint procedure, which would have confused you moving in. So during that conversation, I don't think it was clear that Sean Jeffries made what the service complaint process was. Obviously getting in touch, getting the details, getting in touch with myself via my email of your service complaint. I mean, how that part was left, even listening to the call, that part of the conversation, even from what you mentioned that he was going to give her comments due to the decision that she's made. At the same time, you was going to give me the comments because from the information and what was made in that conversation, from my belief, it was led, you kind of was misled. Not misled, but the instructions were not clear at all. So from that pattern, I could see that you wasn't kind of given the clear instructions to go, right, if you're wishing to raise a service complaint, this is the process that you should be going to. With your comments, I would need to take your comments on before processing to the next stage. So even with that, I have upheld that, and from reviewing the case investigation with Sharp, I can see that there was need to be more clarification with giving the correct service complaint procedure, and this has been fed back to Sharp to ensure Sharp understands the proper service complaint procedures as well.
Okay, well, haven't you not just contradicted yourself here now? Because in the first complaint, obviously what I had highlighted was the resistance. You said there was no resistance, but yet in the second issue, you're saying yes, there was resistance.
Resistance? No, this is regarding the information. So she didn't resist to give you the information. The information was unclear of what she was giving you. So the unclear part of it was the service complaint procedure, because you mentioned, because during the discussion it was mentioned, right, so given the comments about the decision that you've given me, and do I feed, I'll feed these comments back regarding the service that you provide to the team, to your team manager, which correct you into saying, right, what needs to happen is your comments need to come to myself, and the service provider feedback needs to go to the TL. That wasn't mentioned.
Well, did she not? Did she not concur? Did she not concur with me that I said I won't be dealing with you anymore, and I will be raising the comments that you require back to your, to your service or to your team leader or something? And she said okay at the time, and I think that's what this complaint was about. Is that on the telephone call, obviously I was very disgruntled by her decision. I said, obviously I wanted to speak to the, somebody, complain about the situation. She's not taken a proactive step. I believe you believe that she's been proactive in giving me the details, but then obviously what subsequently happened is that I said, look, I wanna, I'm gonna be lodging this with you, obviously I don't want to deal with you anymore. I'm gonna be giving you the comments back to your manager and stuff. And on the call, she had agreed with me, and then subsequently in writing, she had asked for those comments. So that was what I think my complaints was. That during the call she had conceded that I could give the comments and feedback to her decision to the service manager, which is yourself, and it was right. It was not it was she was complied to she was required to tell me that, no, Mr. Hussain, I require you to give me the feedback. My manager won't be looking into this, because obviously this is my investigation aspect, and it's beyond his scope to look into this. But she didn't do that. She, on the telephone call, you see that she's agreed with me. She said, okay, that's fair enough. And then subsequently after the call, she's then advised me in writing to give her written comments. And if she had told me on the telephone call that, oh, Mr. Hussain, no, the comments and feedback needs to be given to me, and my service manager won't be dealing with this, then I would have proceeded to say, okay, well, can we arrange, if that is the case, because obviously I'm complaining about you, I don't want to deal with you anymore. But what you're telling me is that no, it is you that needs to get the feedback and comments regarding her decision, and so therefore I would have then necessarily arranged another telephone call with her. But because she said, okay, I agree with you, you don't want to deal with me anymore, that's fine, you can give the comments and feedback to my manager and stuff, which obviously then upon reflection after the call, she wrote to me saying that she wanted the in writing from me. So that's where my issue is that she shouldn't have told me to give the feedback and comments to the manager, or the to yourself, or agreed with me on the telephone call, and then subsequently required me to put things in writing, when she knows full well that I would rather give my comments feedback orally, which is then what I proceeded to indicate to her, that I will be obviously needing to speak to you again.
Yeah, and I can see, and what you mentioned obviously during the phone call, she's made it quite clear what the instructions are. When you receive that letter, you wouldn't have felt, but hold on, this is not what's been said on the phone call. Because obviously that part of the conversation, which I'll clearly say, it's kind of left unclear as to what the next steps for you were to take on a service complaint, as in a service complaint and the comment.
Yes, but is it not? Did she not agree with me upon reviewing the call? Did she or did she not agree with me that I could give the feedback and comments to you as the service manager that she required, that she had requested? She requested comments and feedback.
Because how it ended, how the conversation was, is that you kind of asked, can this information be given, my comments and my feedback, to your manager or TL, how you mentioned it, and she mentioned yes, where
Yes.
you should have actually said,
no.
Service complaint, feedback goes to the TL, your comments need to come to me, so
yes.
I can then forward it on.
Okay.
Okay.
So
I feel upheld that side of it.
Okay, so you have upheld it that she said yes when she should have said no.
I'll upheld the fact that she should have basically said no, this is the process, but she said yes, and then obviously sent a letter which kind of conflicted
yes.
what was mentioned
That's
to yourself with regards to what the action to take with
yes.
the comment
Okay.
and the service.
Okay. Okay, all right. So you've upheld this issue of the complaint. In the telephone call, she had said yes, I could give the comments and feedback to the manager. Subsequently, she wrote back, no, you need to give those comments back to me. And so that's the end of the matter. That's been upheld in it. So my complaint here has been upheld.
On that part surrounding that, I can see that there would have been confusion for you not to be giving clear instructions.
Yes.
On moving to.
Yes, because I had asked her, can I give the comments and feedback to your manager, or I want to give the comments back to your manager. She said okay, or agreed with me, or said yes, and the reality was that I couldn't. Yeah, so you've upheld that one. Okay, I mean I got nothing to complain about now, have I? You've upheld. I've said that she's done something wrong. You've said yes, I agree. So. There's not that I can't raise anything else that you've upheld that. Yes, she shouldn't have done that. She should have known better and said no, I require the comments and feedback. And then is it not the case that she had required the comments and feedback in writing from me? And obviously that was a further issue that I had raised, because if she subsequently, basically, she's agreed to something on the telephone, then obviously realized that actually that's not correct, maybe after consulting you or maybe after taking further advice, then she's written out to me saying no, I need those in writing now, or I need your feedback and comments in writing now, and then she's proceeded to present that, and now that has obviously led to the fact that I was not I would have not been in a position to put things in writing, or I wanted to speak to her. So that then has necessitated another call, hasn't it? So she should have basically said, okay, well, I made a mistake here, but she's effectively tried to cover up her mistake and saying, no, give me the feedback now in writing, rather than saying, look, obviously I was wrong here. Can we arrange another call? It was upon myself to actually arrange another call after I had, obviously thought on our last call that we won't be speaking again. I was put into that situation. I think taking responsibility for her mistake would have been the right course of action. However, what she chose to do was basically try to say, well, put it in writing. Now, ordinarily that would have been fine, but because of the standard that we had established, that any kind of comments or feedback I would have to give orally, because that was what I was expecting to do on the last telephone call, she's attempted to ask me to put things in writing, which has further exasperated the situation, requiring me to say, no, I want to arrange a further call to give you the feedbacks. That's correct, yes?
So basically, in this surroundings, what should have been done is correctly, first of all, there should have been the correct procedure given to you over the phone.
Yes.
There should have been a correction which would have been given to you as to this is the process of what's been needed, this is the deadline for when I need it, this is what I actually need from yourself, and a clear instruction as to this is how a service complaint will be dealt with, this is who you directed to. And then, yes, obviously from that part of the phone call, I did find that there was no, as I said, I upheld what you're saying, because I didn't find there was enough evidence or there was clear discussions given, instructions given to yourself, which would have led you to be able to go through the correct procedures of a service complaint, as well as giving your comments.
Yes. But then obviously, what's happened subsequently, moving on from that, is that she's attempted to get me to give the feedback and comments in writing.
Right, yes.
Yeah, and she knew that was because I explained to her of my adjustments, that she should not have asked for the things in writing. She should have said, "Look, we can arrange another call."
Right. So, I mean, for the reasonable adjustments, I've got a point picked up on there as well regarding reasonable adjustments, but I can go to that, which does touch onto that part as well, because during that there was a conversation on the 11th of May, same conversation, which what I would need from the information that was given on the 11th of May, it was then made aware that you was dyslexic, and she did confirm with you. Also, she offered to provide alternative methods of communication to support the reasonable adjustments, which you advised you was quite happy just to continue with the way that the methods of instructions were being sent out. That was on the 11th of May.
Yes, but like if he's accepted the reasonable adjustments, which is obviously speaking to me rather than like, asking me for things in writing, then why has she then proceeded to ask for things in writing?
Oh, from the conversation, it was mentioned that you were dyslexic. She's put that on a sheet. Is there any alternative methods of communication that would support for any reasonable adjustments? Which you advised, no, you was quite happy.
No, but the reasonable of course, I mean, if I'm speaking to her, the reasonable adjustments is that I wanted to speak to her rather than put things in writing. Dyslexia is a problem with reading and writing, isn't it? So obviously, if she's
I'm dyslexic myself.
Yeah, you mentioned that. So can you understand if I was happy because we were speaking on the telephone? So right now, if you tell me, Mr. Hussain, I'm aware that you've got, you have this dyslexia. Are there any reasonable adjustments you would like me to do? Right now on the telephone, I can say no. Because we're speaking, we're not reading, we're not doing anything in writing. However, if you were to say to me, okay, Mr. Hussain, after this call, I want you to put something in writing to me. Well, I think then that is questionable, isn't it? If you and I agree that there's no reasonable adjustments required right now in our communications because we're speaking. If you ask me for some information, I'm willing to provide it to you. However, when you say, look, I require some information, and I said, no, I don't want to give you that information because I'm not happy with you, can I give that to your manager? You said, yeah, that's fine. So there's still no reasonable adjustments required right now. The reasonable adjustments failure happened when, after the call, realizing that that was not correct, the feedback needed to be given to her, she's then asked me for things in writing, which then obviously I feel she's not taken into consideration what she's already accepted. So after the call, she then proceeded to ask for her comments and feedback in writing.
Mm-hmm.
And that is an aspect.
During that call, it was obviously mentioned, and from the take of the call, when asked, if there's any alternatives, obviously it was mentioned I'll get something sent out to you in writing as well, which was mentioned on the call.
Yes, that's fine. You can send me things in writing, but what she required from me was feedback. So you can send me some information in writing, that's fine. But when you require something from me, obviously I would rather give it orally. So she required feedback and comments from me, not to provide me with something in writing.
Yeah.
I mean, obviously, much like yourself, I accepted things in writing, but when I want to give feedback or when I want to converse with somebody, obviously I want to do it orally. So what's happened is subsequently, after the call, she's accepted that I've got dyslexia, that those are the reasonable adjustments that I require to give information orally. But then after the call, she's realized that it is myself that needs this feedback, and obviously Mr. Hussain just told me on the telephone call he does not want to speak to me anymore. I've advised him go to my manager. However, I do need this feedback, and then she's proceeded to request that in writing from me. That is where I feel the aspect of not discrimination or not reasonable adjustments have been taken into consideration by Miss Jeffries. Because if she should have said, well, actually after the call she should have said, well, actually I would like to arrange another call because it's myself that'll be taking this information. But she's proceeded to ask for that information in writing. That's where I think that my grievance is.
I'm putting this down, and what I'll do, I'll file this as part of the stage one as well.
Okay, all right.
because I can see where your point is, and this is why I'm just saying from my investigation, from listening to the call, do understand that obviously from those methods, it was mentioned about dyslexia. Obviously, reasonable alternative methods were given. However, during that time, it was, from what you're saying, is she should have said to you at the end of the call, I'm going to be, would you prefer it? If you need to get back, what are the options to get back? Now, from how she sent the letter out and to what ended of the call, I do believe that she has followed the process. But obviously, from what you're saying, you feel that she should have been given the fact that you was made her aware of dyslexia. She should have obviously, you're saying that she should have made you aware that if you are going to get back in touch with her, it would need to be done orally instead of in writing, given the reasonable adjustment
Yes.
that you would have needed.
Yes, and I think this is a continuation, like basically a cover up or attempt to rectify a mistake which you already conceded that she had. On the telephone call, she had asked for comments and feedback. I said, I don't want to speak to you about this. I'll give the comments and feedback to your manager. She's agreed to that. So that's where the mistake is, isn't it? And then subsequently, she's realized that my manager will not take the comments and feedback. So then she's asked for that information in writing from me. What she should have done is said, well, at that stage, put her hands up and said, look, I obviously made a mistake here. And said, look, and ordinarily, she could have asked for that information in writing ordinarily if I hadn't informed her of the reasonable adjustments. So she was aware of the reasonable adjustments, but then obviously she required the feedback from me, from myself directly rather than going to her manager, and so she's proceeded to ask for that in writing, and that's where I'm taking an issue, because knowing the fact that I wanted to give her feedback orally, and knowing the fact that I had requested to give that feedback on comments orally to her manager, which she's mistakenly told me I can do so, she's then proceeded to ask for the feedback and comments in writing. And because she's asked for those comments and feedback in writing, I feel that she's not made the reasonable adjustment, because what she should have said after the call is that I will be requiring it is myself that will be requiring the feedback and comments, and as a result of this, I'm happy to arrange another follow-on call. So that's what should have happened. But she's attempted to effectively get me to put things in writing now, which is obviously the reason I've complained to yourself, is that she's because I was led to believe after the telephone call that I would be looking to give the feedbacks and comments orally to her manager. Then subsequently, when she's put that in writing saying I want it in writing, I've then had to proceed to engage with her and say, well, actually, if you're now telling me that you need this in writing, then can we arrange another telephone call? On which has proceeded, where I think sometime in June I've rang her again and we've discussed the comments and feedback, haven't we? So, but that was once again instigated by myself, saying, well, no, actually, now that you're saying that the feedback cannot be given orally to your manager and you need it in writing, then obviously I will require now the reasonable adjustments to speak to you, and she's agreed with that. But once again, it's an aspect of her not taking the lead upon this, her requiring me to put things in writing, and for me to say, well, no, I've made you aware that I don't want to give my feedback and comments in writing, I want to give it orally. And then eventually she's had to concede to that. But can you understand, it's like that's where the problem is, that she's knowing the fact that the reasonable adjustments need to be made, she's disregarded them and asked for comments and feedback in writing, not recognizing that if she did that, she could have said, look, Mr. Hussain, actually what's happened here is that I need the comments and feedback from you in writing. However, I understand the reasonable adjustments and I'm quite happy to entertain another follow-on call. So if she had done that I think would have been a reasonable way to approach the situation. But she's effectively not giving me the option of speaking to her, and then I've had to say, well, according to my reasonable adjustments, I require to speak to you.
I'm just putting this down just to put on further notes for the stage one.
Okay.
So I think that clears the reasonable adjustment point, as well as the misleading information. So that's 2 and 4, because the reasonable adjustment speaks about that as well. So it kind of combines. On part 3, I can see there's been a typo from myself just on the date. the 14th of April. That should be the 4th of May on there. So this was inconsistent and conflicting information was given surrounding presentation of delivering evidence.
Okay.
So from reviewing the evidence, the telephone conversation made on the 4th of May and the 11th of May between yourself and Sean, I found that Sean had advised you, it should have been the 4th of May, that she would need to get advice on the method of providing evidence, of you providing evidence. On the 11th of May, Sean made you aware that from the advice that she had received, your method of delivering evidence would not be acceptable. She then provided you with alternative methods. You could have used to provide your evidence.
Okay, all right. So what was I complaining specifically about here? Because what had happened was that it was an evidence. I was actually in that on the 4th of May. I was in a conversation with her regarding her evidence request. And she had informed me at that stage, because I think the evidence request was required by the end of April or something, and she had made an evidence request in April for that information, and I was quite insistent on, like, in the telephone call, she had advised me that she's given the other party, the other party, basically the service provider, has requested extra time. And she asked me if I needed extra time, and I was saying no, I don't need any extra time. I'm quite happy to give you the evidence right now. And I explained to her my evidence request is basically a URL link. So she took down the URL link, thinking it may be like a link to a website or something like this. I then proceeded to inform her that these are all my telephone call recordings between myself and the service provider. And at that stage, she stated to me that, I'm not sure if we can review YouTube videos, because I explained to her that there are effectively YouTube videos of call recordings, and she goes, I'm not really sure about if we can take that as evidence. Now, but my understanding was that I had made her aware quite earlier on in the investigation that my evidence would be provided as call recordings. On the 4th of May, she had advised me that she was not sure whether she could accept that evidence in that format. Yes, so she would need to get she would need to get advice, and then I said that's fair enough. So there was no issue there, because she's obviously she's asked for evidence. I've looked to provide that evidence. She's taken the evidence, but then when I've made it clear to her that the YouTube videos, she's a bit taken back by that, because obviously that's unusual or unprecedented. So she said she needs to get further advice upon that, and I said that's fair enough. So that aspect of it is fine. So there's no confusion there. I've tried to give her some evidence, and she's advised me that she'll need to speak to the Ombudsman to see if you can be accepted. Yes. So there's no area of complaint there. I think that then subsequently what's happened is that, if memory serves me correctly, is on the 11th of May, she said that not only will we not be accepting the evidence in a YouTube format, but it's the fact that we want you to clip out the evidence to specifically deal with the points that you've raised. So effectively what I've done is I've obviously given her the whole you can call it the term data set, the whole call recording, all the full data set, and she's basically turned around and said, not only do we not accept it in that format, but what we want is, this is the format that we require from you, like basically in an MP3 file or something. But then we also require you to, we don't want to be listening to all of it, or we want you to clip out. We want you to review it all, clip out the necessary bit that supports you, and I think that's where I've really taken an issue with this, because obviously I've collated all this information, and I'm quite happy to for it to be fully reviewed, or at least accepted. And then I think that's where the disagreements between myself and Miss Jeffries have started, because I've said that, well, this is a highly resource intensive activity that you're now requiring me to do in order to assist you in your investigation. And I did not say no, but I was a bit reluctant, because obviously it would have meant the fact that I would have had to review all the call recordings myself and clip out bits, then change the format of them basically from the YouTube videos in order to record MP3 files, in order to then present them, in support of one particular complaint. And so therefore I just felt that once again Miss Jeffries effectively was looking to get me to do her job for her, and that's what I think where the complaint arose, is that it's not so much that you don't require it in a YouTube format. I mean, I'm quite happy to, as you can appreciate, everything's backed up, so I could have easily proceeded to download all the YouTube videos onto a cloud server and then give you a link to the cloud server. But then even that would have not been accepted, because it's not the fact that it was on YouTube, because remember she told me that I'm going to find out if it's acceptable that we can have access to YouTube, because as you can appreciate, different companies have different policies, but effectively she's told me I'm not sure if we can accept it in this format, namely YouTube, access to YouTube, because we're not given access to YouTube, which is fair enough. Many corporations don't want their employees to be watching YouTube videos whilst they're at work, so they may restrict that. And so she needed that clarity on the 4th of May. However, when she's come back to me, she could have said, well, no, Mr. Hussain, we don't have access to YouTube. Would it be possible for you to provide them in a different format? So I could have said then, yes, not a problem. I could quite easily download all the videos and put them onto a different, put them onto a CD or a USB, or put them on a cloud server and give you a link. But then obviously the criteria changed, saying that it's not just the format. It's not just the format that they're on YouTube. It's the fact that there's we don't want all of them. We want you to go and clip out the relevant bits for us and put them into an MP3 format. And that's where I felt that that was slightly disingenuous or slightly vexating for me, because what you're effectively asking me to do now is, provide you with evidence, and I think this is just a broader approach that not only Sian Jeffries has taken, on which obviously I'm in disagreement with the Ombudsman. And I explained to Miss Jeffries that, look, all I'm asking for is for them to provide, the service provider to give all the case file, and then obviously I'm quite happy to assist the investigator, basically point out certain things in a complete data set. However, the approach taken by Miss Jeffries, and she's explained to me that this is the approach adopted by the Ombudsman, is that no, we're only going to ask for piecemeal information, all right, snippets of information. And I take issue, and this is an issue I continue to take with the approach by the Ombudsman, because if I, for example, let's just give this as an example. If I had proceeded to clip out some information, so I had not provided you with a complete data set, but I listened to Miss Jeffries and said, okay, I'm going to give you little clip outs of short form content, let's just say, just to meet that criteria. Can you understand that leaves me now in a position to manipulate? Because obviously I can take things out of context. I can take a small thing and say, look, they said this. So I can say to you, I can just say a little comment to you, say, to get you to say something, and then I can later on say that, look, oh, you were saying these things. All right. So I can say, for example, I can say to you, say the N-word for me out of context, and then I can clip that and say, look, he's being racist towards me, use the N-word against me. All right. But that's not, can you understand? That is a form of manipulation that's open to abuse. So that's one of the reasons that I was quite happy to give her the whole data set, and then quite happy to assist, her with, using that as a basis of a foundation upon which can't be disagreed with. I can't later then remove things. And what the approach taken by the Ombudsman and yourselves is that you've not asked for the whole case file, and now what you're going to do is that I'm relying solely upon the solicitors with the little snippets of evidence that they provide, which obviously in isolation would help prove their point. However, if you look at the fuller picture, and if I can get the whole data set, namely from the other party, then I can say, well, no, actually, they've provided this in out of context, and in context, you can see that it loses all value. So that's the general disagreement I have had with her regarding this matter. So it's not the case that she's come back to me with saying that, oh no, we can't have it in the YouTube format. The confusion arose is that she's then changed the goalpost and saying, I want it in this particular method. namely snippets of short form content to accept, to back up my point. And I just understand that that is open to abuse and manipulation by me, because obviously the other party, they don't even have access to this data set, which is my call recordings. So if I was to not openly declare that to them, and the other party can then say, oh well, Mr. Hussain has pointed out certain snippets, but here, look, even according to his own evidence of the call recording, we did actually do this on another day. So for example, I could have said, look, I asked them to give me a call back, and they didn't call me back, so here's the evidence of me asking for the call back, and then removed the fact that they did actually call me back. And they can say, well, no, we did actually call him back on such and such a date. And I can say, look, that's not in I don't have any evidence of that. Can you understand? That opens up a whole aspect of abuse of process or abuse of manipulation. And that's what I generally took a disagreement with Miss Jeffries on. And it was not something that I had closed off, but that was then utilized as a means to state to me that I was being disagreeable with the ombudsman. So that's why I think my complaint arose from the fact that she had advised me that she was looking to get further advice regarding YouTube. And I said, okay, well, that's fair enough. But then when she's come back to me, she stated that not only do we not accept it in YouTube or any other format, but this what you've presented to us as evidence, as everything. We don't want it as everything. We want you to go through it all and pick out the little bits that we require in order for you to support your argument.
Okay. So, I mean, from you made clear points of, the fact that, given what you said, for you to snip up, you didn't want to snip, the contents of the evidence because it could erase to each case of manipulation, which, is very transparent for you to say that. From the advice she was given, because the advice was given from an ombudsman, the only way they would have accepted it is through the processes as she's been advised to do. So from there, the reason why they asked for snippets is because what's the relevant part of it to your case? So we can only take the snippets of it. So from that line, I can get what you're saying, because your disagreement, I think, is not solely on Charles Jeffrey's decision, it's on the process. And
no,
that's the process that she was instructed to take.
Yes. But then,
evidence has been provided.
well, just to jump in there, yes, I mean, my disagreements is, as I've explained, is twofold, isn't it? It's just basically she's told me she needs to get some more evidence regarding, she needs to get some more advice regarding how the evidence can be presented. And my understanding then was that, okay, maybe it won't be, you won't have access to YouTube, but then obviously she's come back to me, like you're saying, from the ombudsman, saying that we only require that snippet of information. And that's obviously, even now, obviously, I'm articulating my disagreement with that decision that's been given to her by the ombudsman, but that then has been utilized as a means to end the investigation. All right, as one of the criteria is that, obviously I was not looking to cooperate in that manner, and I think that's where a further issue, so for example, she's got advice from the ombudsman. Obviously I've disagreed with the advice of the ombudsman, and I'm quite happy to obviously work with her, negotiate with her in a different way, but she's utilized that as a pretext to end the investigation. That's where I take an exception, because I did not, if I had turned around and said, nope, I'm not gonna snip out anything for you. This is the only way I'm gonna give something information to you, and this, and the other. I did even make it clear to Miss Jeffries that if she's requiring this from me, that I am not obliged to give her any evidence, am I? I don't have to provide her with any evidence. And she's agreed to me, yes, you don't. So on the one hand, I've looked to present her with evidence in a format of a YouTube videos, like the whole thing. She's come back to me and said, well, no, not only can we not accept it in the YouTube format, but more importantly, after taking advice from the ombudsman, we require it from a snippet format, because that obviously will reduce our time in having to look through it all. I've then said, well, that the reason that I have then sat and explained to Miss Jeffries, I think in June, that I can understand that everything that the ombudsman do or anything that somebody has to do, it has to be an aspect of reasonable, doesn't it? So I said to Miss Jeffries that I understand how under normal circumstances, like for example, if I had a case with the solicitors and it had run for, let's say, 5 years, and only the last month or so I'm raising the complaint with them, then for the ombudsman to say to the solicitors firm, no, hand us all 5 years worth of documents and we want to only look at when the complaint only, that was an aspect of unreasonable. So I understand how an ombudsman would make a policy saying that we only require the relevant information. However, I advise Ms. Jeffries that under my particular circumstances, from start to finish, the complaint are 20 and they encompass everything. So it's better, or it's more, rather than asking for, it becomes very resource intensive to snip out little things, even from the solicitor's perspective, because it's just easier to just hand everything over now, because it's like from start to finish. And this case with the solicitors only ran from April till, I believe, end of, like, till January the following year, maybe a period of maybe 8 months. And so Miss Jeffries has said, no, I won't be doing that according to the Ombudsman's decision, that we only require snippets of information, evidence from the service provider. Then I said, okay, well, I think that's a wrong decision, because everything is unique and discretionary according to the circumstances. I think the circumstances in my case warrant the full disclosure from the service provider of the case file. If you're choosing not to do that, that's fair enough. But from my perspective, my evidence, which the service provider cannot give you because they didn't record the call recording, I'm going to give you everything. And then for her to say, well, no, I require you to snip it out, I would have said, well, obviously I'm gonna show resistance to that. All I was doing was expressing resistance to that. It was not discompliance. The worst case scenario, I could have said, okay, well, you don't need to, your investigation does not need to rely on any of my evidence, and I won't be providing you with any evidence. Is that okay? And she said, yeah, that's fine. You don't need to provide me with any evidence. But where I take issue with, and where I'm taking this as a grievance, is that she's utilized that as a means to end the investigation.
And from what you mentioned, obviously, from me reviewing the case, and obviously she's been getting advice from ombudsman along investigating the case as well. So I can see where your point is, from her coming to a conclusion to where she's come with a complaint. Obviously, I can't go into detail with the case itself.
Yep.
As I said, dating from that, and that's kind of like going on to another part, which is obviously not remaining impartial during the investigation. So this is part of that. Each step that Sean has taken during the investigation, from what I've assessed, has been she's remained impartial during each stage, and obviously advice that she's been given with the evidence, yes, quite clearly. What we're saying is from when you spoke to her, you mentioned what kind of evidence she was providing. She mentioned she would get back to you with that and kind of get the evidence, get some advice on that. The evidence from the advice she was given, she followed that to the point. And that's advice given from, obviously, I think you were Ombudsman, to obviously give that advice. And from what Sean has taken from that advice, she just followed the instructions that she's been given.
Okay, no, I'm not. That's not. Basically, look at it from an objective perspective, which you're stating that you're. Yeah. So look, basically, the reason for the call on the 4th, because she had made an evidence request. I then proceeded to, in my capacity as not being, obviously a layman, or not being, familiar with your policies and procedures. I then proceeded to provide that evidence. Maybe not in the correct format, but as a result of me providing the evidence, I should not be discriminated against. So that you agree with me that if all I've done is provided the evidence, all right, and by providing the evidence, I've effectively been discriminated against, because that's then been utilized as a means to end the investigation. So, for example, I'm just thinking to myself, well, what have I done wrong here? If, for example, Miss John Jeffries said, look, I'm making an evidence request from you, and I would have said, under these circumstances, I do not want to give any evidence, or I do not have any evidence. I don't, the evidence that she had initially anticipated was documentary evidence. And remember, all the documentary evidence is on the other party, because what she anticipated, and as the ombudsman, what you anticipate as evidence is documentary evidence. And then obviously I would have said, normally, let's just say for argument's sake, I hadn't recorded any call recording. I did not have access to any of the call recording evidence. I would have then been solely relying upon my email exchanges. And let's just say I had an email failure, or my email was not available to me. Everything in writing. Basically, if Sean Jeffries had then asked for an evidence, I said, I'm sorry, I can't provide you with any evidence, but I would like you to still investigate this based on entirely on the evidence from the other party, because the other party, as a solicitor's firm, have documentary evidence. So I will be then solely relying, and that could have been a way forward for me to proceed, and that would not then have been used as a means to end the investigation, would it? Because on the 11th of May, Miss Jeffries has told me that the evidence that you submitted, that is now, I've made the decision that to end the investigation. So it is correct that Miss Jeffries advised me that she ended the investigation. Was it on the 4th or the 11th?
The case hasn't been, the investigation hasn't been ended yet.
No.
She has found reason to obviously dismiss it, which I think that from where we last spoke, she sent out the reasoning to yourself.
That's fine. That's a separate matter. But I'm just focusing it on the 11th. So on the 4th, I've rang her up. She's asked for evidence. I've provided the evidence orally by giving her a link to a YouTube playlist of all the call recordings. So I proceeded. So on the 4th, she could not have made the decision to end the investigation on the 4th, because on the 4th she's asking for evidence. I've proceeded to provide the evidence on the 4th. She said that I don't know if I can accept this evidence. I'll need to get some advice from the ombudsman. And then from the 4th to the 11th, a decision has been made by her to look to end the investigation. Yes. So she's advised.
She advised about the decision to seek to move this to dismissal.
Yes. So what has changed? So what has changed from the 4th, where the case was, she was satisfied? So something's clearly happened, and that something must have happened between the 4th and the 11th, because obviously the other party, she advised me on the 4th that the other party, I'm not even given the evidence. So no change of circumstance has occurred, has it? The only change of circumstances has occurred. 2 change of circumstances have occurred as far as I can tell. The first change of circumstances, I proceeded to reply to her and give her the evidence. So that, and then I'm just saying that has been utilized as a means to end the investigation. But in addition to this, I'm not sure if you're fully aware of this, but in addition to giving evidence, now as you can appreciate, I have been giving Miss Sean Jeffries other information which is not evidence, which is, I would classify as opinions, and those opinions are based to give the person correct perspective. Now, can you understand, like in evidence, and evidence, like, this is my understanding of it. So let's say if an evidence is an A4 piece of written document in English. If I give you that document in English, written in English, you can read it from top to bottom and you understand it. However, if I give you that document upside down, you can't read it properly because it's upside down. Alternatively, if I give you the document in English, but however it's a mirror copy, namely everything's upside down or back to front, because there's a mirror reflection as a document, can you understand? Even though you have the evidence, you would have problems reading it or deciphering the evidence if you don't have the correct perspective. So then all I've done is I've proceeded to give her the evidence, and also anything outside of her evidence request that I've provided information on is simply to get her to have the right perspective. And what that right perspective is that there was something untowards happening in relation to the solicitors colluding and conspiring with the judges and everything else. So all I was trying to say that, look, there's a perspective that not only has the solicitors been acting malevolently, and this is the perspective why they've been acting malevolently or with malicious intent. And so what I've proceeded to do after my call with Miss Jeffries on the 4th of May, I've then proceeded to email her and included the Ombudsman with my formal complaints to the police. Have you managed to review that document?
Have I managed to review the document that she sent, that you've sent with the evidence? Is that what you're saying?
No, I said because the evidence that she requested was presented to her orally over the telephone as a URL link. Okay, so I told her, look, this is the link to the evidence. Yeah. However, following the telephone call, I had sent an email to both Miss Jeffries and is it John Edwards? The Ombudsman's name is, what's the Ombudsman name? Paul McFadden?
Yes, Paul, Chief Ombudsman.
Yeah, so I've sent an email to both Paul McFadden and Sean Jeffries on the same date, and it's basically my complaints to the Greater Manchester Police and allegations of murder to them. Did you review that document?
Did I review the document? If it was regarding the case itself, I haven't reviewed the document.
Okay, that's fair. That's fair enough. Yes, I understand. Yeah. So that's fair enough. So basically, the reason. Sorry, basically, so you wouldn't have reviewed that document because that's part of the case file, isn't it? But all I'm trying to establish is that between the 4th, when Miss Jeffries, I rang up to give her evidence, to the 11th, where her decision has been made to effectively look to end the investigation, what is the change of circumstance? One of the change of circumstances I've given evidence, because is surely me giving the evidence cannot be used as a means to discriminate against me, namely that, so that can't be right. Or alternatively, it could be the fact that I directly emailed the chief executive, Paul McFadden, with this evidence regarding the police, regarding the complaint to the police. So either one of those two things has resulted in the investigation looking to be ended. Because otherwise, in the absence of that, or the Ombudsman needs to give me an understanding of what's happened. Because, between these two dates, something's obviously happened and has necessitated Miss Jeffries to state that, we don't want to end the investigation. And I believe that then obviously any kind of pretext has been utilized. And one of that pretext has been that, the evidence was not in the right format and Mr. Hussain was disagreeable to provide it in the right format. So then obviously that's been utilized as a pretext. So I'm just trying to understand that between the 4th and the 11th, something has clearly happened that has look to end the investigation, and it cannot be simply me providing evidence, because on the surface of it, that's the only thing that you have the fact that and that doesn't seem right, does it? It's like if Miss Jeffries has asked for evidence.
So that conclusion from the evidence, and this is what goes on to what I was saying, not very impartial during the investigation. An ombudsman will be has picked up case into a level 2 ombudsman, so it comes to level 1, it's actually going further up to level 2. That will be giving you, that is reviewing and giving you a decision in very close due course. You should be receiving that. And they would be able to go through how the decision has come to arise, and then go through their decision making.
Okay, but we're not talking about that. That's what something is going to happen. I understand that's what I'm just looking at. What I see, I can't comment upon that, and neither can you, because that decision's not been made formally. Yeah. It's not been given to me, so that's not a point of discussion. What is it?
I'm going through what you mentioned between the 4th of May and the 11th of May. Mr. Jeffries made the decision that the case may, it would need to be looked at as a possibility of being dismissed.
Yep.
That's where I'm saying from that point, because I can understand that, when we last spoke before we went into length as to the reason why she came up with the opinion that it may
Yes.
reasoning as how she got there, as in for a personal investigation. What I can see is that she's gone through the correct processes to obviously warrant to come up to that decision. I know what you're saying now is, but from the formal when you advised about your evidence and what you've provided, to the 11th when you hadn't even provided any information, but she still had come up through the process of dismissal. During those cases of investigation at the stages that she's came from, it still led that Sean can still go to that process, given the fact that from what she had investigated on the court, on the case, due course up until the 11th, she felt that the case would be due to dismissal based on what she's investigated from there. Looking at the steps that she's taken, she's correct into, as in being able to have that option to go to a dismissal. That's what it goes to an ombudsman to make that decision as into why. No, sure. Why you came up with this decision? Two, is your decision actually rational, or is it, is it correct? That's why it gets overviewed for an ombudsman.
Yes, no, I understand that. I understand that. I understand that. No, that's fine. What I'm trying to say is that yes, just give me 1 second. I'm just trying to what I'm trying to understand is that first of all, Miss Jeffries cannot make it. Then when exactly did the investigation start? Because my understanding of, maybe it's a terminology issue here. The Miss Jeffries' investigation formally started obviously when she's been speaking to me, and this is the formal process. But an investigation, it means, from my understanding of the word, is that you then look at the evidence. So because the evidence had not been submitted, what has she investigated? This is the whole point I'm trying to say, is that yes, the case had commenced back in January, and we're at the preliminary stages of getting my complaint down, going to the service provider, getting their feedback, and so on and so forth. So by the 4th of May, the investigation has not commenced. And the reason that the investigation has not commenced is because you can only investigate evidence. You can't investigate a case. You investigate the evidence. You have to look at the facts and establish facts and evaluate the case based on the investigation, on the evidence. So because on the 4th of May, Miss Jeffries had not received any evidence, the investigation part of it had not even commenced yet. She's then obviously made the decision based upon her rationale of and she's then effectively look to find a pretext or an excuse. I would argue, obviously that's something that's debatable, but it's not clear to me that what could I have done or what have I done. It seemed on the surface of it that she's asked for evidence, I've given the evidence, she didn't like the evidence, and then she's used that as an excuse to look to end the investigation. That's what it seems, because in the absence of that, if for example,
and I totally, from what you've mentioned, you've given your argument as to that is how you believe, how she's come up with this, came up with this process. Now, obviously, she's given the reason that she can't see any reasonable success under that part. The fact of what she comes with evidence. I know that she said the reason for you as to why she came up with that, and from that time. Now again, this is going to be reviewed by an ombudsman.
Yeah.
We're checking if in actual fact she's come up with that process is correct, and obviously within the opinion on there. Now, as I said to you, this is moving on to stage 1. So I'm taking the notes that you're given, which you're unhappy about. I have given my resolution on that, and again, obviously from what I mentioned, with regards to the processes that she's gone through, and also for it to be impartial, that's the reason why I stand obviously with those two parts as effect to kind of saying.
Okay. Well, let's just move on. Let's just move on.
So the next point would be extra time is given to service providers to reply to premature complaints and will provide evidence that the deadline dates were not disclosed when requested.
Yes. Okay, well, we've gone over not remaining impartial during the investigation. Just to go back one step, because obviously there's a reasonable adjustments were not supported during the investigation. We've highlighted that. And what I meant by that is obviously we've gone over that. I was dyslexic. She asked for things in writing, and so we've gone over that. And then it's a not remaining impartial during the investigation, and obviously that is something that the ombudsman can look into. And I think what we just discussed now here is that that's one aspect of it. But this extra time given to the service provider, that this is, if I remember correctly, she's informed me that on the fourth that the service provider has requested extra time, and then I pressed her upon that, and she said that until the 22nd, I think, of May, that they requested that they requested some time. And so she's informed me when regarding the extra time requested, but she's informed me of the extra time on the 4th of May. So when on the 4th of, pardon?
The conversation was on the 11th of May.
Yeah, no, but obviously she in the conversation on the 4th of May, she's advised me that, because I remember on this call that she was saying to me that, do you need extra time? I'm happy to give you extra time, just as I have given the other party extra time. And I was quite insistent on her to say, no, I don't need extra time. I'm going to give you my evidence right now. So that was on the 4th of May. So I think on the 4th of May, she's advised me that she's given the other party extra time. Now I'm not sure if it was on the 4th of May or whether on the 11th of May. She's advised me that, obviously I have granted them extra time. All right, so
on the day so 22nd of May.
So she's advised me that I'm going to give them extra time. Then what's happened is obviously she required my comments and feedback. I requested to speak to her. I spoke to her in June, I think the 6th of June or the start of June. I then asked her, well, have they complied now? Has the other party complied with the evidence request, because they had requested extra time? And she had said no. They had I asked for extra time, and I've given them extra time again. And then I said, well, then my complaint that you've told me before on the 11th or the 4th that you've given them until the 22nd of May. Now I'm pressing upon you to give me the date of when they must comply. And she's to this date refusing to give me that extra time. As you can see from my email correspondence with her as well, I'm asking, okay, well, look, we're going from something definitive to something abstract now. So we've gone from something definitive. She's asked me specifically that I need you to give me the evidence request by a particular date. I think the 5th of April. I contacted her, spoke to her on the 5th of May. I contacted her and spoke to her and said, look, I'm going to give you my evidence in time as per your requirements. She's told me the other party have requested an extension to the 22nd of May. That's definitive. And then obviously subsequently when I've spoken to Ms. Jeffries at the start of June, I think the 6th or the 6th of June, she's once again been very insistent upon me that she needs my feedback by a particular date, because she cannot escalate the matter to the ombudsman until she's got my feedback and comments. That did not take place until our oral conversation at the start of June. And in that conversation at the start of June, I asked her that did they comply by the 22nd? She said no. I said, well, what's happening now? She said, I'm going to give them more time. And then she's refused to give me the further time. So that was my complaint. And what did you find as a result of investigating this?
Well, I've gone from, because obviously from the time of the call, I can see that she's mentioned that she has, on the 11th of May, she gave obviously evidence between yourselves, found that she undisclosed as to why extra time was given to the provider, and also confirmed the date of 22nd of May. Now, obviously, when you last spoke on the 6th of June, she mentioned that she has not received the evidence from the service provider as of that timescale, and will be taking matters and to chasing the service provider. It was obviously then asked, what's going to be taken further, or how long it's going to be provided. And at that point, Sean did advise that she is dealing with that matter with them and then looking to proceed that. At the same time, at the moment, while there was still the 5.7 in progress, obviously she is waiting for that to come back, and she's still chasing. Now, given the circumstances, how I'm come from this, come to this conclusion
yes.
is that based on the fact that she did give the date of when
Hi, Sean.
the service provider was providing evidence, when she was again chasing the service provider, there was no date actually given because she was chasing the service provider for obviously the evidence, and also from there on, obviously what matters she was going to be taking with the service provider would be between her and the service provider at this point of where the investigation is. As I mentioned, as previously mentioned, any request can be taken after the case has completed, which would give you a providing of information. During that time, though, on the 6th of June, from what I can gather, is that Sean was chasing the service provider, and she was in a right to kind of like a feast between her and the service provider at the moment to be obtaining this information, and the same would apply if the service provider could ask for that information from herself as well.
But no, Jake, well, my complaint specifically is that she had given me the date of the time extension of on the 11th of May. She had given me that I've extended the time, because obviously there has to be, we're working with deadlines here, aren't we? Or we're working with specific dates. Yeah. So she's asked me. So on the one hand, this is where I think that impartiality is brought into question. Look, this is the rule we're going to have. We require the evidence request by we're making an evidence request. We require a response by a particular date. That's what she's told me in April. I've then responded with that evidence request by the 4th of May. She told me that the other party have asked for an extension of time, and I've agreed to that. That's her discretion to do so. Not a problem. Now but I'm aware of it. I'm in the loop. And so on the 22nd of May, remember on the 22nd of May, she's not referred this matter to the Ombudsman as yet, because she's not got my feedback. So no doubt on the 22nd of May, she necessarily would have said, either chased up the service provider, or the service provider would have contacted her, stating the fact that 22nd of May has happened, and we require further time. But when I spoke to her on the 6th of June, remember, she could only make the referral to the Ombudsman after getting my feedback, which I gave feedback and comments on the day, on the 6th of June. So on the 22nd of May, the service provider should have provided the evidence, complied to the evidence request. They hadn't done so. So she's advised me, I've given them an extension of time. And no, I'm not disagreeing with her on that. All I've asked for is, just like before, just tell me the date that you've extended the time to. And I don't understand why she can't. If she's given me the date beforehand that she's extended it until the 22nd of May, and then the second time she said, I've given a further extension of time, then why is she not telling me this?
From this matter, from what I can see from notes, is that she was ineffectively chasing the service provider.
No.
Information.
She's asked for an extension of. She's informed me that they've asked for an extension of time. So on the 22nd of May, that that's what the deadline for the evidence request was. When I spoke to her on the 6th of June, she told me that I've extended the deadline date for them to comply, and I said, well, what is that date? And she would not give me that date. It's not that she was chasing them up. Is that what was she chasing them up? You should have complied by the 22nd of May, or what was the new date? Because on the telephone call, she's told me she's further extended it. So when I said, okay, if you further extended it, what date have you extended it to? So I wanted something definitive. So it's either the case that from the 22nd of May, when the service provider should have provided the response, they've either not responded to her and she's chasing them up, and by the 6th, when I'm asking her, well, did they comply by the 22nd of May, she's either told me not a truth by saying that, I'm still chasing them up, they're not got back to me. She could have said that. But what she's definitively told me on the 6th is that they've asked for a further extension of time, and I've granted that to them. Okay, so then the natural question is that, okay, so they didn't comply by the 22nd of May. You no doubt had been in communication with them. They've asked for more time, and that's fair enough. And you sort of seen it fit to grant them more time. Just give me the date then. And I don't believe that she could give me the date because there was no date. That's what my understanding now is. Because why would she not give me the date? But if there was no date, then why did she tell me on the telephone that I've further extended the time with them? So moving away from the ombudsman, moving away from everything else. Remember, this issue arose in April. She made an evidence request to both parties. I had complied by the 4th of May. All right, that she had told me on the 11th of May, or she had told me on the 4th of May, the service provider have asked for extra time until, and I then I had to press her, what date is that? 22nd of May. Fair enough. Then when I next spoke to her in June, on the 6th of June, I said, did they comply? She said, no, they haven't. And the reason that they've not complied is because they wanted extra time. And I said, okay, so you've extended it again. Can you give me the date? And then she refused to give me the date. That was my complaint. Why? Either she extended it and there has to be a date, or she was still chasing them up. If she was just still chasing them up, then my complaint is that why did she tell me on the telephone on the 6th that she's extended it? All right, and then if she had extended it, then why? My complaint is why did she not give me the date?
Right. So what I will do with this one, because it's just some more relevant information with this, is for that one I'm going to again go over the call on the 6th of June, because I've got this on the 11th of May. So going through the call on the 6th of June, which I have listened to, but I'm going to listen to again just on this one part and just find out. So I just want to get some. I just need to find out, why it wasn't given again on that day. I find out specific reason. But what I will do with that, Mr. Hussain, is on that part, I will make a note of that to the service, to the service complaint team as well, to just move over that aspect of
Okay.
Okay. That opinion on that.
Okay, so. Okay, well, thank you for that. Yeah, so all you're going to do is you're going to review that call and determine one key fact. Did she state that I've given them an extra time on the 6th of June? All right, that's what you're trying to determine. If she had stated that she's given them extra time, basically she's re-extended it, then did she re-extend it? That's what you need to investigate. That did she give them extra time, or did she just tell me on the telephone that I've given them extra time? And then when I press, and if she had given them extra time, then quite clearly that would have. You don't just give, say, indefinitely, do you? So if she had given them extra time, then why had she failed to disclose that information to me on the 6th? So those are the just very simple things that you can evidently be faced.
Do you want the I can have a look at that, because I've got an idea, but what I want to make sure is just get it confirmed. That's all. Without giving my opinion, without giving my review as to why, but I just want to get it confirmed and get a second opinion. So I'm giving you, I've got substantially giving you the correct information on that.
Okay.
Would you want that to be in the stage 1, or do you want me just to come back to you with that section, even though your whole complaint is still going to a stage 1?
Yeah.
Would you want the stage 1 to highlight that in there?
No, actually, what I would like you to do is, because this is still like a resolution stage, and maybe it's something that was being overlooked or not clarified at the resolution stage. For on this particular complaint, I would still want to stay at the resolution stage for you to get back to me and say, well, actually, I maybe misunderstood or didn't get exactly what I was supposed to look into. I'm going to have another look into this and get back to you. So I would like you to just utilize not the stage 1, but still at the resolution stage of actually looking to get to the facts of the matter. As you can appreciate, what's infuriated me is Mrs. Jeffries' refusal to give me an extension date. Not saying no criticism is drawn to Miss Jeffries of extending it a second time. That's her discretion. She's the investigator. But I think if she's given, it's reasonable to say that if you've previously given me the extension date of the 22nd of May, why have you not given me another extension date specifically? And then if she has not extended it, effectively what you're saying is she kept on chasing them up, then why did she give me some false information on the 6th by stating that she had further extended it? And then because either she had extended it on further extended it after the 22nd of May, or she hadn't done so. If she had done so, then she was obliged to give me the date on the 6th, and she refused to do so, and that's my complaint. But if she hadn't extended she could not give me the new extended date because she had not extended it. Then my complaint is that she had deliberately given me some false information by telling me on the 6th that she's further extended it. So those are the specific areas that you would like to look into and get back to me on. Is that clear?
Okay. So just on that notion then, before just going to the last part, I'll hold to stage 1 because I'll get this part investigated.
Yeah.
And then I'll come back to you with this part 6 and what I've reviewed as well and what my conclusion is with that. Once we've gone over that part, then I will have everything pieced together and then escalate it over to the stage 1 because rather than leave part stage 0 and then other parts in stage 1, it'd be best if it all goes in as one.
I understand.
So
I understand.
What I can do with this, I can get this investigated. I'll do this investigation myself. One thing I will say though, Mr. Hussain, I am very short on time at the moment, but I do go on annual leave from tomorrow, so I'm just trying to gather when I can get a time. And so we can make sure that we're on the same page and there's no misunderstandings from how we go about delivering this section 6 of it. Right. How would you prefer this to be fed back to you first of all?
Well, the thing is, if, for example, you concur with me and say, yes, if you, like, after investigating this and you say, well, yes, everything you're saying is correct. I've listened to the call. Miss Jeffries did tell you that she has extended it. In my investigation, I found out that she hasn't extended it, and I'm upholding it. Or alternatively, you say, well, yes, I've looked into this matter. Miss Jeffries should have did actually extend it, and she should have given you that information. Then all you can really do is just uphold my complaint and say, yeah, that's fine. I've after looking into this matter, I'm upholding that complaint aspect of your complaint, and that then would not need to be escalated to the stage 1 because, as in the previous complaint, if you uphold my complaint, it doesn't require somebody else to look into it, because the only reason somebody else needs to look into it is because where there's a disagreement between me and yourself. So if there's an agreement between us that what I'm saying is correct, factually accurate after having investigated it by yourself, then the matter does not need to be escalated to the stage 1 because there's nothing to escalate to the stage 1. You fully agreed with me. However, after following your investigation, you determined that no, what I'm telling you is factually inaccurate. Miss Jeffries did not say that she's extended it. I've reviewed the call and I cannot see any evidence of Miss Jeffries stating the fact that she stated to you that she had extended it. Then obviously you can write to me on that basis, but then you also need to explain to me, after reviewing the call, the justification of why Miss Jeffries, after having extended it, has failed to give me the date of the extension. And obviously that needs to be, I think you would agree with me that if she's given me the extension date in the past, and this is an aspect of like vexatiousness or infuriating me, is that I'm simply asking for a date of the extension. So I think the best way to do is that if you find what I'm stating, if you disagree with me, then it's upon yourselves to give me that in writing, initially, as you've done previously. Give me that in writing, and should I feel it necessary to have another conversation, so I can get the clarity of why exactly are you disagreeing with me of what I've said, I may look to have another conversation with you. Or alternatively, I can say, Jake, the reality is that you and I were never going to agree upon this, and I would like to elevate this to a stage 1, and I can do that in writing to you. So the options are this: that either you agree with me fully, put that in writing, and the matter is ended with. Alternatively, you can disagree with me, put that in writing, and then leave that to myself to respond to you, whether I want to respond to you in writing and say, well, please can you escalate this to the stage 1 as well, or alternatively, before you do so, maybe I've misunderstood something, so can we have a follow-on call? How does that sound to you?
Yeah, that's fine. So what I'll do then, by close of business, the 27th, right, I'll have a resolution for you in writing on section 6.
Okay.
and we have the next point, the last point that we've got, which is about to attend the call plan for the 10th of March 2023.
Yes. So, do you have access to Miss Jeffrey's work log or work record?
Yeah, so I've reviewed the file, and I've yet to find any evidence that shows that a call was arranged between you and Sean for the 10th of March. However, I can see that there was an email, Sean. I can see that you emailed Sean on the 9th of March confirming that you were satisfied with her update on your case, which she gave you on the 7th of March.
Okay. Well, the thing is, I'm sure I spoke to Miss Jeffries on I think the 7th of February on the telephone.
7th of February?
Yep.
Okay. Would you want me to review this call?
Well, just before like I said, I'm just trying to recall things off the top of my head. If what had happened was that I think at this stage, or at the start of February, what had actually happened is that Miss Jeffries had made the decision that because I'd put further preemptive complaints in, that those now need to be presented to the solicitors, and as a result of being presented to the solicitors, they would require some more time. So she said, look, I'm going to be gracious enough to give them more time. And I said, well, what date do we need to, what date are we giving them? Because as you can appreciate from speaking to me, I like to work with definitive dates.
Yeah, exactly.
So
Expectations.
Yeah, so just for my expectations, so I know what to come back up on. Now, my understanding was that I'm just trying to look through here now. Yeah, so Miss Jeffries had arranged for a date, and given she had been the one that had arranged the date, and I think it was the 10th of March. That's what I'd stated, isn't it?
Yeah.
And that I think that concurs with 4 weeks or 8 weeks. I'm not sure, but when we last spoke, Miss Jeffries had told me, well, I'm going to give them until the 10th, or give them until the 9th, I think it was. Give them until the 9th of March. So I had agreed to speak to her on the 10th of March. Okay. And so she had suggested the date, and I had agreed to it. However, I think the reality is that 10th was a bank holiday. Friday the 10th was a bank holiday, and so was Monday the 13th was a bank holiday. Is that correct? Was it a bank holiday?
I'm trying to say, I don't know if it was about the 10th of March was a Friday.
Yes, but I think it was a special bank holiday.
Could it potentially be April, 10th of April, which is a Monday?
Are there no bank holidays in April? I'm sorry, in March.
Let's have a quick look for you. I don't think there is, but I just want to confirm. There was one on the 10th of April.
Oh, there was,
only March.
Yeah, sorry. I think that there's my confusion there. Is that it was she had arranged for a time on the bank holiday, and when I've realized that this is a bank holiday, I've then obviously raised upon it. But we had arranged for it must have been the 10th of April then. I must have made a mistake there.
10th of April is a bank holiday. What I'll do with this one then, Mr. Hussain, I'll take this back and go and have a look at that, because I've gone from your instructions, which is 10th of March. Now, obviously, from us having a discussion, it could possibly be the 10th of April. I'm quite happy to go back and review that, just to check what was made on that one, and come back to you on that.
Yeah, that's fine. I mean, if you can just look into that email exchange, because she had arranged because I think that makes more sense, because I think when we spoke in February, you usually give them 8 weeks, don't you? Not 4 weeks. So that seems about right. Okay. So when I spoke to her in February, but I can see that I spoke to her on the 18th of March as well. So I spoke to her on the 7th of February and on the 18th of March. Now, my complaint here was that my understanding was that there was we're going to speak next on sometime on the she's going to get back to me on the 10th of April, but like I said, the 10th of April
Bank
was a
holiday.
bank holiday, and I've taken issue with that because I once again it was myself that had to approach her and say, look, it's a holiday, and we were supposed to have a conversation here, and so then it was, I would have thought as a professional it was her job to say, well, we've made a mistake on booking this on the 10th, before the 10th, and she could have told me that, can we rearrange. It was myself once again instigating the fact that a mistake has happened, namely, but it's a bank holiday, you've not got back to us, when can we speak next. And I think we did speak next on the 14th of April. So we spoke on the 7th of February, 14th of March, and then the 15th of April. Sorry, 7th of February, 14th of March, and 14th of April.
Mm.
However, when we.
So 7th of February, 18th of March,
No, no, sorry, 14th of March.
14th of March.
And 14th of April.
So you spoke on the 7th of February, 14th of March.
Yes. And 14th of April.
And the 10th
No,
of April, that's when it should have been a call.
we spoke on the 14th of April. I'm just looking at my records now, but we had booked. We were supposed to book on the 10th of April. That's when she told me that we'll be speaking next, or we're looking at a range of appointment on the 10th, and 10th was a bank holiday.
Okay, so what I will do, because remember we spoke before and you wanted to know when I was listening to calls, when I was getting my resolution.
Yep.
Now, what I will attempt to do is that I'll attempt to listen to the calls either on the 24th of July. And also possibly through to the 26th. So I'll try and find pockets of time to listen to the calls around the 24th and the 26th, and I'll have my resolution sent out to you by the end of the day on Thursday the 27th.
Yeah, well, that's fine. Thank you for that definitive guideline. So obviously, I'm fully aware of what's going to be happening now, and thank you for the time of going through these with me. I mean, I think I'm satisfied that we've gone through all these now quite extensively, and I've provided that. Issues. You've looked to fully address. I'm very satisfied that the way that we've handled this. You've spoken to me, and we've gone through all the your investigation findings. Obviously, there's still a couple that you're going to look further into. You're going to get back to me on the 27th after having reviewed them, the call recordings.
That'll be sent in letter. That'll be sent in a letter. Yeah.
Yeah, that'll be
a letter sent out to you.
Yep.
Probably by the end of the day, the 27th. I'll get that sent out for you. Just to make you aware, I'll hold it off from going to a stage 1 because I need to complete stage 0. Because there's aspects that obviously brought further evidence with it just for me to go and have a look with, which I'm quite happy to do. I want to get these boxed off first of all. I know that you mentioned if it's agreed, you're quite happy with it and it doesn't need to. But as you can imagine, if I'm moving over to a stage 1, I want to make sure the relevant stages and points of the complaint are where the stage is to go to a stage 1. So it's just the correct procedure.
Yep.
So what I'll do from here is that the key points that you picked up is on number 7, which need to be looked at with the dates, because you've given me new dates, because obviously we found out the 10th of April could be the date that you've mentioned from looking at it. Number 6, obviously, have a look in the pool for the further extension. And from there, I will get my conclusion put together on those 2 points. I'll send you an email at the end of the day on the Thursday, the 27th, which will have those 2 points on there. Obviously, as you've explained, if it is forms that I'm still in agreement with my resolution and I still say that they're not upheld, you've advised me that if you are to disagree with that and you still want to move it to a stage 1, you'll have some time to think about it, and then you could possibly contact me to arrange a call to go over it, or you might, however you want to proceed with speaking to myself. On that matter, as soon as I find out from yourself, I will put on here, on the letter that I'm sending to you, we'll have a deadline and a time scale, say about 2 weeks for you to come back to me with your comments. And if you are happy or unhappy, I'll proceed with which other points are to be moved to a stage one, or if you, for any reason, are just quite happy with the resolution of it won't move. But what I will do is wait for your response, and I'll put a deadline on the correspondence that will be sent out to you on that day.
Okay, that's fine. Yeah, that's most agreeable. Yes. Now I'm clear about what going forward, what's going to be happening. So I think this brings us to a conclusion, or we've ended this issue now. I just wanted to ask some further questions, and this is not to do with the investigation, but just with the regard. We mentioned the ombudsman. The Miss Jeffries, told me that after my last call with her on the 6th of June, that she's going to be making a referral to the ombudsman. Now, she's advised me that it can take up to 6 to 8 weeks, and I just wanted to know when I'm going to get a final response from the ombudsman as a guide. You may not be able to give me that information, but considering that Miss Jeffries has escalated this to the ombudsman on the 6th.
I can see Mr. was saying that your case has now been allocated to a level 2 ombudsman. So what I would say is it would probably be within a week or 2 weeks that you should be getting your final response. It is now, I can confirm, with the ombudsman, a level 2 that is reviewing it, and then will obviously take their decision to yourself. I would say, I'll probably say within 14 days to give you like a kind of...
Yeah. So would you be able to confirm when was it handed to the level 2 ombudsman?
So a level 2 ombudsman had picked that up on the 7th. It's been allocated to them on the 7th. They picked it up on the 17th, before I can see.
On the 17th?
On the 17th, yes.
Okay, so a couple of days ago.
Yes.
Okay, all right, that's fine.
I can see there's a request here. It may be a bit earlier than that. I can just see there's been correspondence from the ombudsman, but I do know it's been allocated to a level 2.
Okay, that's fair enough. Now, yeah, that's fine. I just wanted to say, like, taking a holistic approach, it does seem to me that one of the points is regarding the impartiality. I mean, quite clearly, if you are the service provider, namely Burke Niazi solicitors, the present situation that I've raised with yourself is quite clearly geared towards their benefit. What I mean by that is that I've spent a lot of time of my time and resources, articulating and getting these complaints down. Over 20 complaints. They have simply stated, we don't accept any of them. So hence why I'm obviously pursuing this with yourselves. Now, they have not even at this stage, from my understanding, is that they have not even complied with any evidence request. And should it be the case that the ombudsman finds in Miss Jeffries' favours to end this investigation, can you understand that objectively speaking, it just seems highly discriminatory that, as far as the service provider is concerned, they have basically got their cake and eaten it in effect by simply denying the allegations, and also the fact that they've not had to put any work into effectively taking this, going through the case file, snipping out the exact evidence to meet each complaint. That's a resource intensive activity. And so you can understand that when speaking to me previously, that I have a very what others would argue a very conspiratorial understanding of things, where people are conspiring. This does not aid and assist in that understanding. If I'm wrong, then quite clearly that should be evidentialable rather than not being investigated. Now, it just seems to me that the other, like, on the one hand, the ombudsman is explaining to me that we're impartial, and having spoken to myself at length now, you can see the fact that I'm not an irrational individual. I'm very clearly intelligent and articulated, and I'm able to articulate those things to yourselves. And if you're effectively now stating to me that, no, we're upholding or we're ending this investigation, it goes further into that whole understanding that, well, this is a further aspect of collusion, because it seems to me that nothing I'm stating is undeniably not provable. It's provable by the evidence, but if there's no evidence being submitted by the other party, which is effectively getting off scot-free here, that's where I would obviously look to escalate this matter further, because the reality is that, I mean, we all have, like, what's formally what things are done formally. We have a formal understanding. However, we also have a colloquial understanding. Now, having spoken to myself for I would argue in excess of 4 hours, you could see that one of the things I think it would be quite evident for any reasonable person having communicated with myself is that I definitely do not lack litigation capacity. And that is a foundational principle upon which my relationship broke down with the solicitors firm, who are after having spoken to myself and after having me articulated to them that there is collusion between the senior judiciary, they then concluded that I lack litigation capacity. As a result of them making the allegation that I lack litigation capacity, effectively they were not in a position to represent me, which then resulted in my mother dying under unusual circumstances. So you can understand that it's one thing to say, well, we have it on paper that we have to go on somebody else's advice. My original grievance with the service provider is that they have made an irrational decision. Objectively speaking, for someone like myself, I know I'm a very litigious individual. All right, I'm more have more litigation capacity than anybody. I often choose not to take solicitors as representatives and handle cases myself. I was only in court yesterday speaking to a judge, making very much the same argument. So my fundamental problem here is that by the ombudsman effectively ending this investigation, you are effectively agreeing in principle to the solicitors who have stated that I lack litigation capacity, which is I think a very deplorable thing, which has resulted obviously in my mother dying under these circumstances. So I just wanted to finish on that, because you can see that whether you choose to give your opinion or not, because obviously you're holding a professional post, the reality is that I think it would be hard for anybody to argue that I particularly lack litigation capacity, and because the solicitors have made that and staunch decision, that's basically decimated my life. And I would obviously urge the ombudsman to give this the gravitas, the situation the gravitas that it deserves, because I'm not the type of person that's just going to be appeased and go away. Okay, and I'm far more motivated now to expose this. And should I find the case that the ombudsman are equally colluding and conspiring in this this joint enterprise, then I will equally be taking reprisal actions for wasting my time. Now, as you can appreciate, I've spent over 16 hours on the telephone calls between yourself and Miss Jeffries for the matter to be simply whitewashed. Effectively, that's what's happening here. The matters are continually to be whitewashed, and that will not not deter me from my objectives. And I just wanted to leave the ombudsman with that quote, that position, that obviously they should not look to whitewash this matter, because I will not go away easily. The matter is very serious. What my allegations are highly serious. I mean, just for argument's sake, if having spoken to myself, if what I'm saying is true, can you understand this is highly scandalous, where not only my own legal representative, but the senior judiciary, and all the people that we put in place to safeguard vulnerable people have all effectively been colluding and conspiring to my detriment, which has resulted in my poor vulnerable mother dying. So I would urge the ombudsman to not be part of this enterprise by simply looking to whitewash the matter. I just wanted to leave those last comments with yourself, Mr. Osei-Tutu, and wish you all the best, and thank you for taking the time and giving me that opportunity to speak.
Pleasure, Mr. Hussain. Is there anything else that I can help you with?
No, that's fine. Thank you very much, sir. Have a nice day.
You too. Thank you.
Goodbye. Bye-bye. So I just wanted to end that conversation by giving my feedback, because obviously I have recorded this call. I will be making it public, and all I wanted to basically say to the ombudsman, which are equally recording this call, is the fact that I will not go gently into the good night if you continue to whitewash the matter. All I'm looking to do is trying to establish throughout this exercise of going to the legal ombudsman whether they are equally complicit in colluding with the authorities in order to cover up malfeasance. And evidently, as the case stands, the decision is quite simple. In a couple of in a week or two, the ombudsman is going to come back to me with a decision regarding ending this investigation or not. If they make the decision, it's quite simple to me. If they end this investigation after the time and effort and resources that I've put into this, if they end this investigation, they evidence to me at least that they are equally complicit in colluding with the authorities that has resulted in my mother's death or murder. And if they don't if they continue with this investigation, the investigation itself will uphold the fact that if I can bring this case to the ombudsman and have the ombudsman agree with me on every single point of my complaint with the ombudsman, then that quite clearly I do not lack litigation capacity, because I've managed to take this case regarding the solicitor, take it to the legal ombudsman, have the matter fully investigated, and have it totally upheld. Obviously, that's the next stage, whether each one of those 20 complaints is going to be upheld. And I can assure you that each one of my complaints is going to be upheld, because simply my complaints regarding the Sean Jeffries, even though he's tried to whitewash it, Jake Osei-Tutu may have tried to minimize it and whitewash it. Obviously, he's not upheld any of my he's actually upheld one of them, one of the 8, and he was not even going to investigate one of the 8. So when I make a complaint, I don't do it lightly. It's not something that lacks credibility or validity, and that's what I'm trying to establish here. What I say is credible and valid, and has a validity. And for these people to simply say no, what they're basically saying that I lack credibility and I lack legitimacy and I lack validity, and that's what ultimately I'm fighting for, to say that no, I do not lack any of these things, and the matter needs to be. And if it's determined that my complaints are not upheld, then ultimately what you're saying is that I lack basically validity, legitimacy, and these things. So obviously that's why I'm making these quite clear arguments. I've made it quite clear to the ombudsman now, if he chooses to end this investigation, it will be considered as complicity in whitewashing the matter. I mean, it's evident to me that the reason that this investigation has been ended is been ended by the ombudsman themselves telling Ms. Jeffries to stop this investigation, because we don't want to investigate this matter, because ultimately it exposes endemic and systemic fraud and corruption in the authorities, particularly the judiciary or the senior judiciary, and brings the whole state of the state into disrepute, namely the Ministry of Justice, the Health Authority, the local authority, the police authority, and everybody else into a state of disrepute. So we would rather have Mr. Hussain disreputed, and rather than allow our fraud and corruption, or ourselves to be disreputed. So ultimately, that's what it comes down to: who's in disrepute here? By the investigator refusing to investigate this, by the legal ombudsman refusing to investigate this, they're basically putting me into disrepute, basically not saying that I'm reputable. And they are reputable because they have some posts on position. And all I'm trying to state is that they're not reputable. They are the ones that are, colluding and conspiring, and to the detriment of the people whom they are exploiting. So that's all I wanted to say, and I'm grateful for him to have, Miss Osei-Tutu, to have given me the opportunity to have this matter escalated to him, and hopefully we will see where we stand in a couple of weeks' time. Obviously, it's quite clear to anybody, I mean, even to him, that I'm equally reasonable, rational, articulate, intelligent, and capable and competent. What I say has validity. Even in this call, I've proven it to him that Miss Jeffries has acted unreasonably by giving me false information. She's given me false information in the telephone call on the 11th of May by telling me that I can escalate my comments and the comments and feedback that she required to her manager, when the reality was that I couldn't do that subsequently. And then she's then looked to ask me to put that into writing to her, when she should have arranged a follow-up call, which was arranged at my behest on the 6th of June. And so she's been caught out on that, but more importantly, I think she's been caught out on the fact that she has, not given me the date of when she extended the solicitor's, extension of time for evidence request. Now, either way, these people are going to say, well, this person's very litigious, very, argumentative. We want to just close this investigation down. And ordinarily, that would be fine, but obviously, they know the fact that I've recorded these calls, and I will be making them public to show the public how even the legal ombudsman are, unreputable, in the sense that they are simply whitewash the matter, and it's a waste of time or resources for somebody to come to the legal ombudsman, as I have done, because they are simply a toothless tiger masquerading as a competent agency. And so I just wanted to make that quite clear. So